In the winter of 2008, a single employee walked out of a heavily fortified bank in Geneva carrying the digital keys to the private financial data of 130,000 clients. That employee was systems engineer Hervé Falciani. He had spent years inside the private banking wing of HSBC, monitoring the data flow of a global financial titan. The data he stole revealed a massive shadow system. It provided evidence that the bank was assisting drug cartels and terrorist organizations in hiding and moving their wealth across borders. Falciani fled Switzerland and handed the data to France's finance minister Christine Lagarde. This information became the Lagarde List, a document that allowed authorities to expose hundreds of individual tax evaders. Exposing this system required an insider theft because international governments are legally blindfolded when it comes to auditing Swiss banks.
If the IRS or a foreign tax agency suspects a citizen is hiding millions in a Geneva account, they cannot simply demand a ledger. Normal investigative channels are completely blocked. This blindness is a legally fortified national barrier. It is written into Swiss law to protect these institutions from any outside scrutiny or regulatory investigation. To understand how Swiss banking achieved this level of insulation, we have to look at the 1934 law that created the shield. In the year 1934, Jewish citizens in Europe were seeking ways to hide their assets from the Nazi Gestapo. They needed a jurisdiction where their home government had no power to track their wealth. In response, Switzerland codified bank secrecy into criminal law. A banker who revealed a client's identity could face prison time. It was a measure designed to protect the persecuted from authoritarian regimes. This document illustrates how that law functions today. Under the Swiss Penal Code, tax fraud, the active forgery of documents, is a crime. However, tax evasion, simply failing to report income, is treated as a confidential administrative matter. International treaties only require cooperation on recognized crimes. Because tax evasion is an administrative issue in Switzerland, Swiss banks can legally reject requests for information from foreign agencies. A legal protection originally written for human rights eventually provided a secondary benefit as a shield for financial criminals. Banks offer specific mechanical exploits to facilitate this concealment, such as the Liechtenstein Trust, a legal entity designed to mask a person's true identity on paper. This paragraph outlines the case of United States versus Kelly. An American promoter used a trust with initial assets of only $20.80 to buy 750,000 shares of stock on credit. The promoter manipulated the stock price to $15 a share. From that initial $20 investment, the profit reached over $4 million.